Welcome back to the channel. In this video, I'm going to discuss what it means to be the executor of an estate or a successor trustee to a trust. So what is an executor and what is a trustee? Is there a difference between them? Yes, there is. So let's first start with their definitions as you can find from LegalZoom. When you die with a legally valid will, a judge will approve the executor you've named in it to act on. A trustee is the person or entity legally responsible for managing assets in a trust and distributing the property according to the trust's terms. The trustor is the person who creates the trust. An executor is the person you name in your last will and testament to carry out your wishes after you die. An executor distributes assets under the probate court's supervision, while a trustee may manage an estate for many years, even for life. While all of this is true, it is so much more. Both the executor and the trustee, well, really the successor trustee, both of their roles are something that one needs to consider very carefully, not just for the person selecting someone to be the executor or the eventual successor trustee, but also for the person or persons acknowledging that they will have the role after that person passes on. And here's why. Being the executor means you become the personal representative for all affairs related to the deceased. This means calling banks, brokerage firms, credit card companies, medical offices, insurance firms, and whomever else is needed to find all of the assets and debts for the person's estate and determine if the debts need to be settled, protested, or they will be canceled or reduced through collections. Then use the remaining funds and assets to handle any beneficiary statements in the will. This also includes gaining access to safety deposit boxes, safes, lock boxes, or other locations where assets may be located. So being the detective or an investigator or working with someone to find where assets are and making sure you are able not only to account for them, so you can handle them related to the estate affairs, which will eventually be to close out all of their accounts and transfer them to the beneficiaries after the estate's responsibilities are handled. You will also help organize, clean, and then negotiate the renting or selling of all homes, vehicles, and other assets that are not listed to go into a trust or to be distributed directly to beneficiaries after handling the holding costs and other expenses as part of probate. If no trust exists, then the executor will be the one who will be paying the bills, insurance, and all the utilities until a renter can be found that will then cover all of the bills of any of the properties or until those places are sold. They will also be handling the drama that will exist between beneficiaries or people that felt they were not properly handled in the will and may attempt to contest it. The executor will also be filing the documents for probate with the county clerk's office to be named officially as the personal representative and either be working with a lawyer or handling this process all on their own, and knowing the type of probate they'll need to do in which county, state, or country. Also, depending on how the will was written, deeds and titles written, as well as the assets or accounts annotated, you will need to be sure which assets actually need to go through the probate process and which do not. And it is often less than you may think. You will need to file and pay their final taxes, and then estate taxes if the estate continues to earn monies from anything that was not transferred into a trust or transferred to a beneficiary or multiple beneficiaries after the first full year, or calendar year that is. So for example, if say they passed in 2022, you need to file their final taxes for 2022, but if the person, because of rental properties or a side hustle or anything else, it still earns money. Now all that money is now associated with the estate, and now estate taxes have to be filed for 2023. The executor also needs to establish the estate account, if possible, or work with some joint account that was created before they passed that has either the deceased person's name and the executor's or another person's name with the deceased person's name to help with deposits and withdrawals. And something to note, that estate account cannot be created until after probate has finished and you have been named as personal representative. You will also need to find the funds and work with the family to cover the final expenses, meaning burial or cremation, ceremonies, plantings, any religious customs, while waiting for insurance and other funds to become available once the death certificate is issued and the appropriate coordination can then occur. Or to say it another way, until funds become available that come from the person that passed on, you're going to need to find funds in order to cover their final expenses in some way. As executor, you will need to have insurance policy, annuities, and bank accounts pay out to beneficiaries and confirm the current addresses, potentially their social security information, besides date of birth information for any beneficiaries, if not all of the funds are going to be going to a trust first. What I mean by this is that insurance companies, annuities, and banks are not going to pay out any policies until they are notified. As mentioned in another video previously, the only entity that tells a bank that someone is deceased is going to be Social Security when they pull back or they rescind a Social Security check. Other than that, the banks won't pay out anything. And it's going to be the executor that's going to be walking through and talking with insurance companies and annuities to validate and confirm payable on death or transferable on death information that exists on those policies so that those things can get paid out. And with bank accounts, if that stuff wasn't known, then it needs to go into the estate and then be worked out accordingly if it doesn't all go into the trust. If a trust was established. The executor will also have to determine what happens with any pets if it's not specifically stated within the will. And if the persons that were stated that we're going to take care of them still want to take care of them after the person passes, or if they're able to. For example, say the person that passed named their next door neighbor to take care of their pet. They might have agreed to it while they were alive, but now that they passed, they might now be in a condition where they need long-term care and they're not able to take care of a pet. So what are you to do next, as an example? The executor will also potentially need to work with lawyers to establish any trusts or accounts specified within the will for any beneficiaries. The executor will also work with law enforcement, the military, or even government agencies alongside with the family and their lawyers to collaborate on any potential criminal or civil cases related to the person's passing, or help coordinate back pay and potentially any Social Security death benefits. The executor will also help to establish the memorial for the person and help comfort the immediate family, besides being part of the phone tree and cyber tree to help with the burial, cremation, and services associated with laying them to rest. The executor will file the will and trust documents with the court or the clerk as part of the probate and clerk records office process. The executor will also eventually sign any deeds or titles transferring assets from the estate to the named beneficiaries. The executor will also potentially work with the state to cancel and surrender driver's licenses, IDs, and ensure the person is off the voter registration if that's not already handled. They will need to get access to the deceased email accounts, phones, etc., so they have the details for any one-time password or two-factor authentication for accounts, besides discover information about policies, bills, or correspondence needs. The executor will need to get access to social media accounts or work with a family member to help get access to social media accounts and other online accounts so that the person's passing can be specified. And then depending on whether or not the account will now be made into a memorial account or not, or just closed out, or even just left to go idle. If the person had young children, special needs children, or responsible for being the guardian of someone, you as executor will need to coordinate the handling of their needs, such as a new guardianship, and establish a trust or funding for them as specified in the will, or potentially what you as executor think will now be appropriate when it wasn't specified. Or work with things that were already previously created for them as the executor to now have them be enacted. So in a nutshell, as becoming the executor, or as the courts will call you, the personal representative, you are now their voice beyond the grave, making decisions for things that were not written or fully specified. You are going to be the guardian of their wishes. And if there are beneficiaries that contest the will, you'll need to work through and handle them, which in the will, it might say that they kind of get written out. You'll need to know how to handle that and to work through that appropriately. If a person dies without a will, someone will need to step up and act as the executor. Also, because there is no will, most likely properties and assets will be lost due to liens, foreclosures, liquidations, or frozen accounts, maintenance issues with any properties or assets, or other drama that will occur from not having a will naming someone to assist with the process and ensuring that they maintained it until distribution. And the person who stands up cannot do anything until they are officially named as personal representative by the court, or the court grants them the right to speak on behalf of the court for the estate by a judge signing off on a letters of testimony or letters of administration. And that process itself can take months or even years. Let me state that a different way. If someone passes without a will or a trust and will, anything that that person owned will potentially get lost because of working through the system with the courts in order to have someone take it over. This is because, again, anything dealing with utilities, anything dealing with properties, anything dealing with any form of financial institution or account needs to have it where there is someone that's recognized as the executor of a valid will to work on behalf of the estate, and in some cases also needing a court to sign off on things to get them handled if there is no trust that handles them a little bit differently. So again, it is a really big honor to be responsible for someone else's life and the estate, but it is a massive burden as well. By law in the US, even if it is not stated in the will, the executor is permitted to take a percentage of pre-dispersed assets as payment for services. This is because this is not an easy task. There will be hours spent on the phone with banks, collectors, mailing forms and documents to various locations, either working remotely or taking time off from one's job to go through the properties, packing and shipping items to beneficiaries, throwing out things or donating them. The executor may even lose their job during the process of handling someone else's affairs. So as mentioned, the executor is responsible for handling the assets and debts and paying the taxes. This means the person needs to be trustworthy, not to steal or take more than what they're allowed. And the beneficiaries also are permitted to work with the courts to do a forensic audit and replace the executor or the executors if they feel the person or the persons acting as executor are not good at doing a good job. The executor therefore must make regular updates to all beneficiaries on the status of the estate. And if it is a sibling that is acting as the executor and they are not on good terms with one of the other siblings and the passing has just made it worse, they still need to provide some form of update, at least say every 3 months or so, until everything is handled. The update can be verbally or electronically or in written form. However, if there's a lot of tension, it might be best to just have everything's in writing, and even some items collaborated with a lawyer to make sure that everything is all documented appropriately. Being a trustee is a little different. The definition I mentioned from LegalZoom is accurate, but in most cases, what the definition is talking about is the trustee and not the successor trustee. The trustee will be the person themselves, and then they will name successor trustees in the trust document that will handle the trust after they pass. The trust that is typically seen is a living trust or a revocable living trust where the person or persons creating the trust maintain it while they are alive, and then they have successor trustees that handle it after they pass on. During their life, assets can enter and leave the trust while paying expenses associated with the living trustee's needs. So what this means is that the grantors or the trustees will use the trust for their own benefit while they're alive. And then when one or both members of the trust passes on, then the trust will handle the deceased person's affairs and the living person's affairs while the other person is still alive, and then be passed on to successor trustees that will then handle things afterwards. Now, after they pass, the living trust now becomes another main type of trust, which is called an irrevocable trust, where the successor trustees manage the assets and financials to pay for expenses associated with the trust, which often starts with estate items and then acts accordingly to handle the specific wishes of the beneficiaries, which are individuals, charities, and other organizations named in the trust. The successor trustees will pay holding costs and other things, and then help with establishing of potentially new trusts with the funds associated with the original trust. As there are a lot of differences between trusts and how they are formed, these concepts will be discussed in more detail in other videos. For now, just understand that trusts and trustees handle the intrinsic value parts of an estate when one is created. And if a trust was created, then the estate and the executors will work with the trust and the trustees to establish accounts that are in the name of the trust for the deceased or for beneficiaries in the will if needed, and if the trust was, again, created prior to the person's passing. Otherwise, all intrinsic and sentimental components will be handled within the estate and by the executor of the estate. Hopefully, the deceased named not only individuals to act as successor trustees, but also a financial institution that offers trust services as part of a private client offering, such as Fidelity, Charles Schwab, BNY Mellon, Wells Fargo, and Merrill Lynch or Bank of America, just to name a few. If a financial institution was named, it is because the person's net worth or their gross net worth after passing was most likely over $1 million, because the institution is going to charge an annual fee and has a minimum asset requirement. If a financial institution wasn't named, then the burden is solely on the successor trustees to manage the funds, the intrinsic assets, and ensure it grows appropriately to meet the purpose of the trust, and it doesn't run out of funds before it is time to pass along assets to the beneficiaries of the trust. This is where the concept of trust fund babies comes from, in case you were wondering. This is because the trust may have specific intervals when the beneficiaries may be paid a portion, like on their 18th birthday, their 25th birthday, or even wait until they're 65 years of age in order to pay out parts or pay it fully out. And it all depends on how it was written. The trust can also be written that the fund will not pay for specific things, or the fund will only go for specific purposes, like only for education, specific kinds of trips or vacations, a home or investment properties that will then go into the person's name or for a person's medical needs. And there could be stipulations on these things, such as, say, it will only pay for a person's education if they get a B or higher, and that kind of thing too. So these things need to be looked over and reviewed as well. If a trust was not created, the executor handles and coordinates all aspects of any type of intrinsic and sentimental assets of the estate until all items are dispersed to beneficiaries as stated within the will. And if there is no will, then based on what they collaborate with the other heirs of the estate and what might be legally decided in various court decisions. Now, just to know is to have these terms of having things happen on someone's 18th birthday, 25th birthday, etc., they don't have to be in a trust. These things can occur and be written into the will as well. It's just that when things are in a trust, they're done privately and they don't need the courts to fully look over and review all of the components related to them. So just like I mentioned before about the executor, a successor trustee's role is an honor, but it comes with a burden too. And if it is not directly specified in the trust document, if the person wants compensation, there is a legal amount that that person or persons are able to take from the trust, from the pre-dispersed assets, because there's a legal amount that they're able to take from the trust for performing their role. So say, for example, the gross value of the estate is $1 million, and legally, potentially, it was, say, 10%. Again, these are all just made up numbers. Then that means that the person could take $100,000 in order to maintain the trust. Now, more than likely, what the number will really be is some percentage, like 0.5% a year or like 1 to 3% a year of the trust while the trust is active and not dispersed to the eventual beneficiaries. Again, the trust itself may live on for years until being dispersed to other trusts in the name of the decedent's heirs, or eventually paid out to charities and other organizations. It all depends on the way that trust was written. The good thing, in a way, is that handling someone's trust is like running another business. It is a lot of work, but at least you're not necessarily responsible to go through their clothes and empty the contents of the fridge and freezer, which happens with the executor of the estate. I'm going to add a brief note before I forget that at the time of this video, I don't know how alternatives to executors or trustees can be handled if they were not named in the notarized or court-filed documents. Meaning, if the executor or trustee died before they complete their task, someone else needs to handle the activity. As I work on additional videos, I'll do research and try to find this out. But this is why it is important to name more than one executor, and if there's a trust, to name more than one successor trustee so that there are alternates that are named. And additionally, it is important to have an estate planner or an estate lawyer work with you during the creation of your will and trust, at least for one or more iterations, so things like this can be discussed. As always, like, subscribe, and share with anyone you feel can benefit from this information. Also, feel free to leave any comments, and I will try to answer them best I can. Depending on what comments are left, it might mean that I'll need to create additional videos to explain them. So feel free to ask away.